Mr. Gubernick?
You're muted, Mr. Gubernick.
I have no question.
Thank you. General Henry?
Thank you, sir, for appearing. I have no questions.
And I have no questions as well. Thank you for being here today. And with that, we'll move to the next person. Is there somebody in opposition, Shelley, for this one?
There's no opposition to this case, Governor.
Great. We'll move on to the next case, Gail Stallworth.
On the screen, Governor, we have Superintendent Wendy Nicholas from SCI Muncie.
Thank you. Thank you, Superintendent, for being with us this morning.
Good morning.
We'll start with questions with Mrs. Grayson. Do you have any questions?
Good morning. No questions. Thank you.
Thank you. Dr. Williams.
If you could, first of all, thank you for appearing. If you could talk about, a little bit about the, sort of the misconducts. And I sort of got the impression yesterday that they were sort of seen as not particularly concerning.
Sure. When she first arrived in 86, while she's had a total of 17 misconducts overall, the bulk of those misconducts occurred between 1986 and 1994, which is relatively normal sometimes for a individual coming in their 20s serving a life sentence. Since 1994, she's only had 3 what they call class 2 misconducts, which are more of minor infractions. None of them were for anything what I would call significant. Most of them were for like what we would call possession of contraband, which I believe one item was maybe food from a dining hall. One was a money order that somebody from outside had sent her that she shouldn't have had, and those types of things. So relatively since 1994, she's been relatively behaviorally stable.
Mm-hmm. Okay. And, regarding her description of, what actually happened at the time of the murder, have you had any concerns about the inconsistencies in her story and, the differences between what she has stated and, what was in the record? Because what we sort of see in the record was a very different person than she portrays herself as being at the time.
I haven't seen any major concerns regarding discrepancies. The one thing I've learned about her specifically as I've gotten to know her over the years, and then more recently the last several, is that when she gets nervous, she's not very good at delineating all the particulars of something. And without specific related questions, she tends to miss pieces, not intentionally, but I know she gets overly nervous and she kind of gets repetitive on certain statements, which can appear one way to us. For her, if you look at some of the background, her IQ is not on the higher level, so some of that may be relative to that and her understanding of the questions. and her ability. She has difficulty sometimes articulating information, especially when she's nervous or in large groups of people. One-on-one, she's a little easier to talk to, but she still has some of that same repetition. I believe not because she doesn't believe what she said. I think she's trying to really express how she feels about what she did.
Gotcha. Okay. All right. Thank you.
Thank you.
Thank you. Mr. Gubernick.
I have no questions.
Thank you. General Henry.
Thank you. I just wanted to get your reaction. I mean, it seems at least to me when speaking with her, although she did seem nervous and was repeating herself as you indicated, it seems that she's never denied, number one, that when she went to that house, it was for something that wasn't good, whether it was to rob for drugs or just take money. She's always maintained that there was something that was going to happen at that house that wasn't good, and that she was the shooter. Is that what you found?
That is what we've seen here. Yes.
Yeah. Okay. Thanks. Because I did think she got a little confused at times, but in the end, those two things remain true. But I appreciate you being here and for your insight. Thanks so much.
Thank you.
Thank you, Superintendent. I don't have any additional questions for you. Thank you for being here today.
All right. Thank you so much.
Thank you. Madam Secretary, is there anybody in opposition?
There are no speakers in opposition.
Thank you. With that, we'll move to the next case, Lewis Dottle, Jr.
Lieutenant Governor, there are speakers in opposition for this case that have not joined the meeting yet. So I'd like to go ahead and move to the next case and we can allow them time to join.
Okay. We'll move to Nathaniel Morre.
Lieutenant Governor, on the screen is Deputy Superintendent Jason Buhinski, and we also have representatives from the Philly DA's office on the screen, on the meeting.
Oh, wonderful. Who is from the Philly DA's office? Because I can't really see them.
Carrie Wood.
Are they virtual or are they in the room with you?
She's on the screen. We're asking her to turn on her video.
Oh, okay. Oh, thank you, Carrie, for joining us. And thank you, Deputy Superintendent, for being here this morning. We'll start with questions, and we'll start with Mrs. Grayson.
Good morning. I don't have any questions. Thank you.
Dr. Williams.
I have no questions. Thank you.
Thank you, Mr. Gubernick.
I have no questions.
General Henry.
I have no questions. I would just note that I cannot see these individuals. I don't know if I'm supposed to be able to, but I can't see the other people.
I can see them on my screen. I can see everybody on my screen. I don't know. Maybe it's just the view that you have. If you hit the top right, there's like a view button for Zoom.
Okay, thank you. I'll try that. I appreciate it, but I have no questions.
Thank you. And I have no additional questions as well. Thank you for appearing today. And with that, we'll move. Madam Secretary, is there anybody in opposition?
There are no speakers in opposition to this case.
Thank you. With that, we'll move to the next case, Betty Heron.
Lieutenant Governor, on the screen is Michael Cole, a program manager from Cambridge Springs, and James Burns, who is here to speak in opposition of the application.
Wonderful. Thank you. Thank you, Superintendent, for being here. Mr. Byrne, good to see you. We will start with questions by board members, and we'll start with Mrs. Grayson.
Good morning, Mr. Burns. I don't have any questions for you. Thank you.
Dr. Williams.
I may have questions, but I if Mr. Byrne is going to speak,
would for board members, would it be helpful if we allowed him to speak first and then went back to questions?
It might be.
Okay.
If we have no questions for Mr. Cole, we'll probably go ahead and just say goodbye to him for right now so that we can just speak to Mr. Burns.
Okay, let me make sure there's Mr. Cole. Mr. Goodman, do you have any questions for Mr. Cole?
No, I don't.
General Henry, do you have any questions for Mr. Cole?
I do not. Thank you.
Thank you. And I don't either, Mr. Cole. Thank you for appearing here today. And with that, you can be excused. Thank you. And Mr. Byrne, if you'd like to go ahead and deliver whatever remarks you might have, and then we'll go to board members for questions. I just need you need to unmute yourself. We can't hear you.
Can you hear me now?
Yes. Can you hear me?
Yes, Lieutenant Governor. Good to see you. Good to hear your voice. Good to be with this board. If you folks can hear me, then with your permission, sir, I'll proceed.
Yes, please proceed.
Thank you very much. I appreciate this opportunity to speak to all of you on behalf of the family, the Herons, David Heron, who was murdered on August 5th of 1981. I come before you on behalf of the family, not only as their advocate, but as a member of the Heron family. My mother's maiden name is Heron, Dorothy Heron. David Heron was my second cousin. I was 18 years old when David Heron was gunned down with 12 shots on Neville Island at the Wind Chimes restaurant. I was about to go into college. I was beginning my career in post-high school education. It shocked the family. David left behind an 8-year-old, Jackie, and a 4-year-old, Beth, who has vague recollections of her father. Beth is with me today with her daughter, a granddaughter that my cousin never had an opportunity to meet. The circumstances at the time are not, I would submit, what have been insinuated or what have been suggested in some of the remarks made by the killer through conspiracy, Betty Heron. At the time, as a young man, I was just getting to know my older cousin, who was 45 years old. He was the guy who never grew up. He was full of life. He was entertaining. He was funny. It was a pleasure to be around him. And as a young man, I was starting to get to appreciate who he was and what he was like. He had a speedboat. He would take me, my brother, my friends out on this speedboat. And back to my point, I read some of the testimony in 1992 when Ms. Heron advocated for House Bill 1382. I read some of her remarks at page 30, insinuating about victims of abuse and insinuating about how domestic abuse was not a choice of a defense at page 30 of that transcript. 7 and 8, she talks about how the nature of women's crimes suggest hidden statistics of socioeconomic strife and difficulty and disadvantage. Those things may be true, and there may be studies that back those things up. And in many instances, those types of situations may be applicable to women who serve life sentences. I would submit to this board that none of that is true with Ms. Heron. I was there. I saw what had happened. I lived what had happened. Victims aren't separated from their spouses. My cousin David moved out of their house in Verona, which, if we're talking about socioeconomic deprivation, it was a very nice house in a very nice neighborhood, and there was no socioeconomic issues in place at that time. David got out of that house. David went back to our old neighborhood where we all grew up in Garfield. David was laying low. David had his daughters with him, Beth, who was 8, and Jackie, who was 4. This big, bombastic man, full of life. This 18-year-old young man, for the first time since he knew David, saw fear in David Heron's eyes. David Heron and Betty were in the process of separating. So these insinuations of domestic violence, these insinuations that she was in fear for her life, I was there, folks. Nothing could be further from the truth. And when you look at the transcripts and you look at the trial, when you look at the Ferrero trial, the gunman who she paid to kill my cousin, and then when you look at her testimony and her reactions and her responses to Prosecutor Lee's LEES questions, you don't see what she wants to posit to you is the person who she purports to be. What you see is a narcissist. I submit that what you continue to see is a narcissist. Narcissistic personality disorder is something, in my opinion, that is almost impossible, if not impossible, to cure. Betty is not the victim here because she is serving a life sentence for a crime she committed, paying a man to kill her husband as they were in the process of separation. Betty Heron is not the victim. Jackie Heron, David's oldest daughter, who died of alcoholism last month, is a victim. Jackie was an 8-year-old girl. She stayed with us a lot during that summer to take a little vacation from where her dad was in Garfield. I saw the change in Jackie Heron after her father was murdered. Jackie Heron was never the same again. I am convinced, because she is my cousin, that Jackie's death from alcoholism last month, the significant contributing factor to her disorder and her disease, there may have been predisposition, I admit, but I believe the loss of her father killed Jackie Heron. So in a way, it can be argued that Betty Heron's actions in 1981, August 5th, a Friday, contributed to the downfall of my cousin Jackie and significantly contributed to her loss. There's another victim in this horrific and tragic story. Beth, who's with me today, has vague memories of her father. Beth has never had an opportunity for her father to walk her down the aisle. And David's granddaughter, who is here, Paige, as well, never had an opportunity to meet that man. I have read some of the posts on social media. I looked again at some of the items and the facts that took place at that time, and I will not repeat them because I know this honorable board has had a chance to look at everything. I do not believe this is someone who understands remorse, respectfully. I do not believe that narcissists understand what remorse is. Narcissists do not see people, they look for opportunities. And I think that that's what we have here. The seeds were planted in 1992 at the testimony regarding House Bill 1382. The seeds were planted then. Everything I would submit to you has been nothing but a cold calculation for this inevitable moment. Our family has suffered since 1981. Our family continues to suffer since 1981. I miss not having the opportunities as an 18-year-old boy to get to know my big cousin in his speedboat and all of the things and all of the life that he had, that he was willing to share with all of us. I miss him to this day. When I went to those trials, I was majoring in English at Duquesne University. I was a junior in high school when Betty Heron's trial came up. Wasn't sure what I was going to do with my life in my liberal arts major. I watched the Ferrero trial. I watched the Betty Heron trial. And out of this horrific tragedy to our family, watching the trial lawyers, watching Judge Bigley in both of those cases, and watching that process, it gave me the calling and it showed me the path that I wanted to take in my life, and that would be to help others through the practice of law. I've been an attorney now since 1988. I would not be an attorney if it wouldn't have been for the horrific actions that happened to my cousin David. Out of this horrific tragedy and this horrific loss to our family, that came out of this. That came out of this. And I'd like to think that David is smiling down on me and the career path I chose, unfortunate as it was that these things had to happen to show me the direction in my life. Honorable members of the board, I was there. Betty's not a victim. Betty was never a victim. Betty was a stalker, in my opinion, and she got her prey on August 5th, 1981. Betty does not deserve a pardon. There may be others in this situation who do, but I was there at the time, and I don't believe that the presentation made, as evidenced by her transcript, and the arguments being made fit the narrative of who Ms. Heron really is. I know who she really is. I know what she really is. This family suffered enough. Please don't rip this open and open these wounds for myself, my cousins, and my family. We would ask that you deny this request, and she must, in my opinion, in my family's opinion, and in the opinion of justice, continue to serve the sentence that she was given back when she was convicted of murder and conspiracy. Thank you for your time.
Thank you, Attorney Byrne. With that, we'll move to any questions that board members have, starting with Mr. Grayson.
I don't have any questions. Thank you for your comments.
Thank you. Dr. Williams.
Sir, thank you for your testimony. I appreciate you coming out today. I just have one question, and I feel free not to answer this question because I certainly don't want you to speculate, but I want to give you the opportunity if you have any thoughts upon this particular issue, and that is, do you have any belief as to the notion of motive? You sort of, you talk about, what you were saying is your belief that the applicant has a narcissistic personality disorder. Do you have any thoughts on motive?
Well, sir, belief is speculation, in many ways. So I don't think I'm speculating when I tell you what my opinion is. I mean,
yeah, and I didn't mean to suggest that you were. I just didn't want to ask you to do something you didn't feel comfortable doing.
Oh, I'm very comfortable with that question. I'm glad, sir, that you asked it. My opinion is it's a narcissist who was not in control of the relationship. My opinion is, and I'm not a doctor. My opinion, being an attorney and being in politics and being around a lot of folks in my practice and in the political profession, being around folks with that disorder, I believe that she had it. I believe that she has it. And I believe that she didn't like the fact that she was losing control of the situation. One reason. That's one reason. I don't believe and you walking away from a narcissist on anything other than their terms, in their minds, is an act of war. And that's what he did. He left. He left in the early summer, and he laid low in the old neighborhood, and the man was afraid. That's one reason. Another, and again, as I recall, and the transcripts may speak on this, my cousin was a Teamster. He was a truck driver. He had finished a shift the night before he was murdered, and he was in a restaurant when he was shot. There may be, and the transcripts will speak on this, the cross-examination of Ms. Heron may speak on this, You'll have to look at this, but there may be another motive other than the narcissism. The motive of finances. The motive of finances. And I think that's something you really need to look at. So in addition to the narcissistic personality, you have a perfect storm with the financial considerations as well. That's how I see it. That's an opinion.
I appreciate you addressing that. Thank you.
Yes, sir.
Thank you, Dr. Williams. Mr. Gubernick?
I have no questions. Thank you for your comments.
Thank you, sir.
General Henry?
Thank you. First of all, sir, thank you for being here today, and my condolences to you and your family.
Thank you, ma'am.
So we had the opportunity, obviously, to speak with her yesterday. And yesterday, I just want to ask you this question because it's obvious that you attended the trials and are familiar with what happened there. And we've all looked at the case very closely, but it appeared that at trials she maintained that she did not hire this individual to kill her husband, that she didn't speak of any kind of marital problems that she was having with this individual, and that she didn't pay him any money at any point for the killing of her husband. And then yesterday, we heard that she's now saying that after the fact, she had never agreed to pay anybody to kill her husband before the incident, but it was only after the fact, after the killing had occurred, that she then paid $5,000 for that. Would you say her position, that position that she's taken, is inconsistent with what she took at trial?
Again, it's been 40 years since her testimony. I did not read the transcript where she was cross-examined for hours by Assistant Attorney Jim Lees. I just remember he did a fantastic job. He was one of the motivators for me to pursue a legal career. I just remember what I remember is her calculation in the answers to his questions. But this after the fact paying the man $5,000 defies logic. What are you paying him for? Does it matter whether you paid him before the murder or after? What are you paying him for? He walked into a parking lot and emptied 12 shots, 2 6-guns into my cousin. And then if I recall, you showed up with him 2 or 3 days later to pick up my cousin's truck. What does it, again, you'll have to look at the transcript on that. It's foggy. Whether I wrote you the check a week before, a month before, or a month ago, you wrote a check. For what? It's, and this denial, or to the extent she's talking about not, the domestic abuse is not an issue. Let me just, I'll find it for you here. I'm looking at the testimony.
Sir,
yes.
I just want to clarify. No, she's maintains that domestic abuse occurred. But what I was saying is at trial, she claimed, I believe, that she never spoke about domestic abuse to her co-defendant. That's what she tried to say at trial. No, I don't want to steer you wrong on that.
I misunderstood.
No. She absolutely was claiming that domestic abuse had occurred in the marriage.
Well, and your question was, is what she said yesterday sound inconsistent?
Yes.
I don't have a clear memory of everything that happened in 1983, but there are things that you're telling me about her conversation yesterday that don't sit right with me. They don't sound right to me. Something feels off to me. And it's a reaffirmation, in my opinion, of her narcissism and just looking for whatever window or opportunity or crack she can get through to get out. That's what it sounds like to me, ma'am.
Thank you, sir.
You're welcome.
Thank you, Mr. Byrne. I don't have any additional questions as well. So thank you for your appearance here today, and my condolences to you and your family.
Thank you, Lieutenant Governor. It's good to see you, unfortunately, under these circumstances, but thank you so much for this opportunity.
Thank you. With that, we will move to the next case, Kevin Coleman.
Lieutenant Governor, on the screen is Deputy Superintendent Martin Schweitzer from SCI Fayette.
Thank you, Deputy Superintendent. Thanks for being with us today.
Good morning.
Good morning, and we will start with questions from board members with Mrs. Grayson.
No questions, thank you.
Dr. Williams?
Yes, thank you for appearing. I would like to ask you to, at first, just speak generally regarding the applicant's misconduct history.
So I can talk to you. What I have is the documented things from his past from SVI Pittsburgh. I can not necessarily speak specifically about them as I didn't know Mr. Coleman at that period of time.
Mm-hmm.
Since his arrival to SCI Fayette, I believe there's been a total of 4 misconducts. I did speak yesterday that although he did have a rocky start to his incarceration, there is a 30-year period of time that he has not received any misconducts for violent acts. No fighting, no assault misconducts. I can't remember the exact date. It is in 1993 when he received his last misconduct for a violent act.
Okay, thank you. Now, I found it to be notable that, you know, Dr. Malashak did not recommend this applicant for commutation. And, you know, he pointed out a number of things that were concerning. And, you know, some of the things, for example, you know, just to start out, you know, with regarding, you know, writing apologies to the victims, or at least to, you know, to the apology bank. Now, when Dr. Malashak interviewed the applicant in 2022, you know, he brought this up, you know, the fact that, you know, there had not, you know, he asked him about this topic, and you know, he had not written anything in 2022. And then, you know, it turns out he did maybe you know, 3, you know, maybe in the last 6 months or something, he might have written a letter. The thing that struck me as being interesting was he sort of made it sound, or at least my interpretation of what he was saying was that he was like unaware that, you know, you could actually do this. You could write to the apology bank or whatever, that it was sort of a common thing to do. And I guess my question is, you know, would this have been possible? Like, could he have gone for all this time at Fayette and sort of have like no idea that you could write, you know, an apology to the apology bank? Would that have been possible?
I guess I could say anything could be possible. That he was, it's my understanding from the conversations I've had with Mr. Coleman, and I think he mentioned this yesterday, is based on the sentence, his sentence structure, he didn't even realize that commutation was a possibility for him until the process actually started. And again, I don't want to speculate that, but that's based on the conversations that I've had with him, based on the fact that he pled guilty, based on the structure of his sentence. He didn't realize that this was even going to be a possibility. He also mentioned that in respect to the apology letters, he didn't necessarily know who to author them to. Absolutely, he could have authored them to those individual businesses, but I can't speak as to whether or not he was aware of the apology bank or unaware of that being a possibility.
I guess yeah, sure. I guess what I'm trying to say is like at, you know, your institution where presumably he's been there for a while, do you have, you know, as part of programming, I mean, do you talk about this, you know, like, is there, you know, do you make announcements? You know, would this be something that someone would see in the reasonably expected to see the opportunity in the course of being in the prison.
I wouldn't say that there's any announcements per se made about it. I know it's discussed, but again, and I really don't want to speculate.
Okay.
But I guess it's possible that he was not made aware of the opportunity to do that. But again, I couldn't speak definitively about that.
Yeah. Okay. No, that's fair. That's fair. Now, just another question. So again, going back to Dr. Malashek's interview, they discussed the whole concept of the Z code, and he said something in the effect of, I sort of have like no idea, why I have the C code. Or he sort of suggested in the interview that a psychiatrist just said, that he could get his Z code so he wouldn't have to have so many cellmates, which struck me as a bit odd. I didn't ask about that, but I guess my question are really twofolds around the Z code. The first is, I'm just trying to get this question in the exact right form. If someone came to you, say from another institution with a Z code, and then, there was like nothing to indicate that, a Z code or an H code, that there was nothing to indicate that either of those were really like deserved, how long would it take for you at the institution to get rid of those codes? Or would they just never be gotten rid of? Could they stay there for 20 years based on the experience at a previous institution?
So they are reviewed. The codes are reviewed. And as I mentioned yesterday, those codes were assigned to him back in, I believe it was 95.
Right.
And they were based upon some of the behaviors that he exhibited back in that time frame. There were some fighting, there were some assault, there was some, whether or not to be accurate or not in respect to that assault, where there was a chemical thrown and a fire, whether or not that's accurate or not, but those were assigned based upon a lot of that information. And typically they're reviewed, and those things can be removed. It's been an exceptional long time since Mr. Coleman was celled with somebody else, so that sometimes is taken into account. And sometimes we reference the possibilities of the previous assaults as to the H code. So there is a review process. Is it possible that it just stays on there? Yes, it is a possibility, but they are reviewed.
It is like an annual review,
yes.
Or
Yep.
Okay. So I guess my final, I don't know if this is a question or a statement, but I mean, he, like, as of now, like, as of this date, does he have a Z code and an H code?
Yes.
So he still, as of today, has a Z code and H code. So I guess my only question is, does it raise concern for you that we are reviewing an applicant for a possible min commutation of multiple extremely violent acts for an inmate that still has a Z code and an H code? In other words, like, is that, like, does that, should that be something that we as a board are concerned about, that, this guy is coming to us still with a Z code and an H code?
I guess the answer for you in respect, when you look at it from that view, sure. But I guess when I'm looking at it from my viewpoint, I look at it as to maybe these things should have been looked into a little deeper during the process of the annual review. I know that doesn't necessarily answer your question specifically, but it again, going back to why it was placed on, and then sometimes a Z code, when it's in place and you prior to that you had issues, and then for long periods of time you did not have issues, you identify the reason that you don't have issues is because of the placement of the Z code and the long-term Z code. So again, I don't mean to dance around your question, just trying to explain that as well as I can.
No, I mean, you've explained it, you've explained it perfectly. Just one final thing. We were, when asked about the misconduct, regarding, trying to set a cell on fire or something like that. Basically what we were told is that I didn't do it. It was someone else. But if I said who it was, I would have been assaulted or killed or something like that, on the inside. Do you find that story credible?
Again, we're talking about a time at SCI Pittsburgh that I can't necessarily speak much volumes about. But sure, it exists where if one inmate were to provide information that implicated another inmate, sure, there's a possibility that they could put themselves in a vulnerable or dangerous position based upon providing that information.
No, and that's fair. No, clearly it's generally credible as a concept. I just meant specifically in his case, but I think what you're saying is that it was so long ago that, in a different institution, it's just difficult to know. So, anyway, I really appreciate your comments. Thank you.
Thank you.
Thank you, Mr. Gubernick.
I have no questions.
Thank you, General Henry.
Sir, I just want to follow up a little bit. Certainly, you're familiar with retaliation in prison. So if somebody kind of snitches or tells on somebody else, there can be consequences for inmates who have to serve significant amount of time.
Sure.
Yeah. And it sounds like when we're talking about Mr. Coleman, he came in to SCI Pittsburgh in the late 80s. So I don't know how familiar you were with SCI Pittsburgh back at that time.
I have no knowledge of it at that time.
Because it's been a while, but it sounds like he got this label, these classifications back then for some conduct that was pretty violent, and it sort of stuck with him. And if I understood what you were saying, sometimes when somebody's been in a solo cell for quite some time and has done well, that may be the reason that they still have those codes. Is that right?
That can be a factor.
And in terms of, and I mean, nothing against SCI Pittsburgh back in the day, but in terms of an apology bank or the ability of whether or not somebody would be aware of it, sounds like a couple things were going on. One, Mr. Coleman, was there and serving his time, never thinking anything. And these, what he's in for, are holdups, where I don't think there was any injury to any particular victims. Is that right?
That's correct. Based upon all of my reading and information, they were robberies. I did not see any injuries, physical injuries, I should say, to any of the people that were involved.
So I think you had mentioned that, since there was no physical injuries, it would be one part of that component might have been, well, who should I write the letter to, versus somebody obviously that was injured as a result of his conduct. And I mean, physically injured. In terms of his, he's, if I understand it, he's recommended by DOC. Is that right?
Yes.
Okay. And I would assume if there's a recommendation by DOC, DOC does not believe that he is a danger. Is that fair to say?
He's had a recent assessment that was completed in July, and that indicated a low risk. We believe, based upon his demonstrated behavior for the last 20 years, and basically he participated in multiple programs. He participated in a program, Bridges to Life, and I don't know how familiar, but we believe that he is a strong candidate to succeed if he's granted this opportunity.
Thank you, sir. I appreciate your insight and knowledge. Thank you.
Thank you.
Thank you for appearing here today. I don't have any additional questions, and with that, you're excused.
Thank you. Have a good day.
Thank you. Is there anyone in opposition?
There's no one in opposition to this case, Governor.
Thank you. Moving on to the next case, John McIntyre.
Governor, the representatives for Mr. McIntyre are not on the line. So while we try and connect with them, could we circle back to Mr. Dottle? We have everyone we need for that case.
Yes. Let's go back to Louis Dottle.
Just 1 second and we'll admit everybody. Governor, on the screen is Superintendent Zakin from SCI Green. And if the board, once the board's done with questioning, then we'll bring in opposition to this case.
Thank you. Mr. Zakin, thank you for appearing here today. We will start with questions by board members, starting with Mrs. Grayson.
Good morning, sir. I don't have any questions. Thank you.
Morning.
Dr. Williams.
I have no questions. Thank you.
Mr. Gubernick.
I have no questions.
Attorney General Henry.
Thank you, sir, for being present and being available to us. I do not have any questions, though.
And thank you, Mr. Zakin, for your appearance today. I do not have any additional questions for you either. Thank you for appearing here today. And with that, you'll be excused.
Thank you.
And we can move to opposition for this case.
Governor, will be admitting Lawrence County ADA Josh Laminkusa and Michael Martin, which is a member of the victim's family.
Trying to get in.
We can hear you, Mr. Laminkusa. Can you hear me?
I can hear you.
Great.
Okay. Good morning, Governor and Warden of Pardons and Parole. How are you this morning?
Good, good. Thank you for appearing here. I think we're still waiting for a member of the victim's family to come in.
Okay. I do have Mr. Martin with me.
Oh, he's with you. Oh, okay.
Yes.
All right. Perfect. Oh, perfect.
Yes.
All right. Well, we will start by questions with board members. And so would you like to give any opening statements or remarks, and then we can go into questions by the board members?
I would like that, sir. May I proceed?
Yes, please proceed.
Thank you. Ladies and gentlemen, my name is Joshua Lamancusa. I am the district attorney in Lawrence County. I've been the district attorney for 13 years. But before that, I was a defense attorney. And then before that, I was in the United States Navy. But when I was a defense attorney, tried a lot of cases, and I always used to argue to the court that my client's actions constituted an error in judgment as opposed to a flaw in character. And that was an argument that I routinely made when I had a client who I thought had some rehabilitative potential, or given the circumstances that surrounded what he was charged with, that it merited some sort of consideration of this one-time incident. But ladies and gentlemen, that's not what we're talking about here. In this particular case, we're not talking about someone who exercised some poor judgment. This is an individual who is a dishonorably discharged Marine who killed his wife. He shot and killed her years later, shot her 2 times in the chest, and then a 3rd time. And I think it's important that we remember that this wasn't a guilty plea. This isn't a situation where there's newly found, newly discovered evidence. That it's not a situation where DNA calls into questions the finding that the jury made. This was an actual jury trial that the defendant took the stand. And after he testified, the jury came back with a verdict saying, "We don't believe you." And they convicted him. Pennsylvania jury convicted him of first-degree murder. And the life sentence that he gave to Teresa Dottle is the same sentence that the jury felt he deserved. Now, as district attorney, I talk to victims all the time. I handle all of the homicides in Lawrence County. I try the cases. In fact, I have a trial starting next week on another homicide. And, you know, when we talk to families and we talk to victims, we always talk about the truth in sentencing in Pennsylvania. And that when you get sentenced to life, well, life means life without parole. And there is a degree of sanctity and a responsibility that we have to ensure that we are going to respect the conclusion and the decision of a jury. And let's not forget, the jury that heard this case, they heard all of the evidence, not the redacted version that we are going to be considering here today. I shouldn't say we, but that you are going to be considering. They heard all of the evidence, and they reached the conclusion that he should be incarcerated for the rest of his life. Now, I'm not suggesting that there aren't cases that do require or should have some special consideration. Maybe there are additional factors, like the person gave information that resulted in the solving of other murders, or helped the government or law enforcement in some other way, or like I mentioned before, DNA or you know, some other exonerating evidence. Those are the types of cases that do deserve merit and should be reevaluated. But the only thing that I see that serves as the basis for this commutation is the fact that he's an old man and he has health problems. I don't know why we would be surprised if someone's incarcerated for life that they're going to have health problems as they get older. And ladies and gentlemen, old rattlesnakes are just as deadly as young rattlesnakes. This is not a case where you get to cash in on the ticket of I'm too old, I'm too sick, therefore I shouldn't be held accountable for the murder that I committed. I think that we have an obligation to ensure that Mr. Dottle remains incarcerated for the rest of his life, pursuant to what a Pennsylvania jury concluded. Thank you.
Thank you. Does the family member wish to speak, or are you speaking on behalf of both?
Yes, sir. He's right here.
Okay, please.
Hi, I'm Michael Martin. I'm Terry Solano's son. My mother was a beautiful woman. She was murdered by this man in 1990. She was an innocent woman. She was shot and killed in cold blood. As he described self-defense, it was, in reality, it was cold blood. And life in prison is life. I mean, he spent the rest of his life with no parole. And throughout years and years and years, we've had to make sure that he stayed there, because every aspect that he got, he tried and tried to get out. He tried to get out under children's laws because he felt that he was a child in law and brain. This man has been nothing but a grievance to my family, to me, to my life, to everything around us. And he's never showed any remorse, not once. Even when a family member went to go visit to see if he was actually a legible person yet, and the only thing that he could do was talk about me to them and how he knew about all my world, all my business, all my life. Why would you intervene, and why would you want to be bothered with me after 30 years of spending your life in prison? So you can get out and, handle business? Is that what we're here for? Because that's what I feel. And like I said, he's never given any remorse to any of us, but nothing but grief. And you could hear it in my voice. It's been grief. 30 years of it. We never had a mother after that. We never had a life after that. My sister, she was 7 years old. She never got a life from her mother because of him. She's been lived in tragedy life her whole life after that. It's been nothing but problems for her. Everybody's dealt with Louis Dottle for the past 30 years. But Louis Dottle tried to kill himself after 2 years of being in prison because he figured that would be a way to get out of prison. And they brought him back to life, thankfully, so he could serve the rest of his time in prison. But in reality of it, he's never served a day in prison. He's spent the time in suicide departments. He's spent time in the library as a librarian assistant. He's now claimed that he's in the lunchroom doing table work, but yet he's in a wheelchair and a walker. So how do you claim tables doing that is a good question of mine. On top of, he looks healthy. There's nothing wrong with him. It's all a game to a psychopath. And that's what psychopaths do. I have nothing more to say.
Thank you. Thank you for appearing here today. With that, we'll move to questions from board members. Mrs. Grayson.
I don't have any questions. I'm sorry for your loss, sir, and for the trauma that you and your family have been through.
Thank you.
Dr. Williams.
Sir, thank you for appearing today. And again, I'm sorry for the tragedy that your family has undergone. I do have a question for the district attorney.
Okay.
Yes, sir. Did you find credible the statements of the applicant yesterday that when he shot the victim, that he was shooting through a door at the door frame?
Well, sir, I was not the district attorney at the time when this case was tried. This was in 1991. But I will say this, that, and with all due respect to the question to you, sir, that for me, looking back at this case and looking back all cases of this same genre, it's not really what I thought. It's what the jury thought. And the jury, who was a jury that came from Pennsylvania, those 12 individuals heard that evidence and they didn't believe it. So they didn't find it credible. And they ultimately convicted him of that first-degree murder, sir.
Okay. Yes, and I know you didn't do the case. I just meant from your review of it and so forth. But that's a very helpful answer. Thank you.
Thank you, Mr. Gubernick.
I have no questions, but thank you for spending the time to come and tell the board.
Thank you, General Henry.
Thank you. Thank you for appearing, sir. I understand that you weren't the district attorney at the time that this case was tried. But I understand your position today is that because of the crimes that this individual committed, that your position is he deserves to spend the rest of his life in jail. Is that right?
That is my opinion, and that certainly was the decision of the jury.
Okay. Are you aware of the offer that was made to this gentleman?
You mean prior to trial?
Yes.
I am not aware.
Okay. Would the offer that was made of 5 to 10 sound like something you or one of your assistant DAs had heard before?
Ma'am, I'll be honest with you. So this was in 1991. There's no one in my office that would have been here when this case was tried. It was tried by, I believe, Judge Cox and Tom Manette, who their judge is obviously a judge, and the assistant district attorney is no longer here. An offer like that, I don't know. That's not something that we would typically do. But I will say this about plea offers. Plea offers aren't it's not a determination as to the appropriateness of a sentence. A plea offer is factoring in, witness difficulty, problems in case, witness availability, differences in testimony. It's not the facts that come out of the trial. It's this anticipation of future problems and its risk management for a prosecutor. So the fact that a plea offer was made can never be in direct correlation to, what the appropriateness of the sentence is. And I say that because, we get child sex cases all the time. And look at a child who has been raped and you think, my goodness, this has to be the maximum sentence. And then when the prosecutor starts looking at the case, he realizes, well, I have a child that can't testify, or I have problems with physical findings, and then a plea offer is made. That is not an endorsement of the severity of the offense. That's the reality of the problems in the case. But once a case goes through the full jury process and it's been tested under the crucible of cross-examination, well, then the facts are the truth, and the jury finds their verdict.
Yeah, I certainly appreciate, as a longtime prosecutor, that offers are sometimes made, and in my experience, for quite some time, we try to make those offers at least, we talk about appropriate, we try to make them at least somewhere near, what we would do. So as you can imagine, 5 years in life are really, quite a difference there, but certainly they're made for a lot of different reasons. The reason I asked about the offers, it's just that somebody from the AG staff had talked to one of your ADAs about the offer that was made, and they indicated that they were aware that there was a very generous offer. So I was just following up with you, but I thank you for your time so much.
And thank you.
Thank you. I don't have any additional questions. Thank you both for your appearance today. My condolences to the family as well. And with that, we'll move on to the next case. John McIntyre.
Governor, participating in this case, we will have Carrie Wood from the Philly DA's office and Superintendent Bernadette Mason from SCI Mahanoy. My apologies, it's Jessica Addy from the Philly DA's office.
I see a Laura. Laura, is she from DOC?
Yeah, my apologies. Laura's device will be Superintendent Mason.
Okay, Laura, you're muted. Oh, perfect. Okay, can you hear me?
Yes.
Great. Thank you. And we will start off with questions from board members for either of you, starting with Mrs. Grayson.
Good morning. I don't have any questions.
Dr. Williams.
Good morning. I don't have any questions.
Mr. Gubernick.
I have no questions.
General Henry.
Good morning, ma'am. Thank you so much for being here, but I also do not have any questions. Thank you.
And thank you both for appearing here today. I don't have any questions. With that, we'll move on to any opposition.
There's no opposition to this case, and it looks like the representative from the DA's office is not actually at her screen.
Okay. Well, nobody had really any questions for her, so.
I apologize. I'm having difficulty lining up my camera, but I'm here for any questions.
So with that, we will now take a brief recess and then return to announce public vote.